You're listening to Clearly Conspicuous, a podcast series brought to you by Holland & Knight's Consumer Protection Defense and Compliance Team. Here at Holland & Knight, we have the working knowledge of how federal and state agencies operate and how courts address consumer protection issues to effectively work with our clients to address these issues.
Good day and welcome to another podcast of Clearly Conspicuous. As we've noted in previous sessions, our goal in these podcasts is to make you succeed in this current environment, make you aware of what's going on with the state and federal consumer protection agencies, and give you practical tips for success. As always, it's a privilege to be with you today. Today, we provide a preliminary look at the direction of the Federal Trade Commission under its chair, Andrew Ferguson. For several sessions, I've been talking about a new chapter at the FTC under Chair Andrew Ferguson. But here's the key message up front. While deregulation and diminishing governmental resources may be a political agenda, the FTC is showing no signs of retreat in its enforcement mission. Let's begin by summarizing some key actions taken by the FTC very recently, which highlights several industries including tech, healthcare, financial services, and advertising. First, the FTC will hold a workshop entitled, quote, "The Attention Economy: How Big Tech Firms Exploit Children and Hurt Families," on June 4th. Next, the Federal Trade Commission and the Department of Justice Antitrust Division issued a joint letter directing the heads of agencies across the federal government to create a list of anti-competitive regulations that reduce competition, entrepreneurship, and innovation. The press release says it is designed to advance President Trump's executive order on reducing anti-competitive regulatory barriers. Then there's the rule on unfair or deceptive fees, which just took effect. The rule prohibits bait-and-switch pricing and other tactics used to hide total prices and mislead people about fees in the live event ticketing and short-term lodging industries. These unfair and deceptive pricing practices can harm consumers and undercut businesses trying to compete fairly on price. The rule also furthers President Trump's executive order on combating unfair prices in the live entertainment market by ensuring price transparency at all stages of the live event ticket purchase process, including the secondary ticketing market. Then the FTC issued a ban on a company and an individual from engaging in debt collection. There's more. The FTC and the state of Nevada took action to stop a wide-ranging investment training and business venture scam that built consumers out of more than $1 billion. Finally, the FTC issued a proposed order requiring Workadoo LLC to stop advertising the accuracy of its artificial detection products unless it maintains competent and reliable evidence showing those products are as accurate as claimed. This sure doesn't sound like slowing down to me. And I note the collaboration with the State Attorney General and international bodies suggesting multi-front scrutiny. Frankly speaking, notwithstanding the current political environment, we must recognize Chairman Ferguson's legal pedigree and strategic approach, steeped in constitutional, administrative, and appellate law. There well might be fewer, but more impactful cases with stronger precedent-setting power. Thus, simply put, the FTC is not in a retreat mode, it's in a refinement mode. So here's the compliance message. This is not the time to relax or retreat. I say all of this to warn against misreading deregulation rhetoric as permission to cut corners. FTC's activity is not slowing, and the agent is demanding proof of effective compliance, not just paper policies. Companies should treat FTC scrutiny like a regulatory audit, proactive documented, and embedded into daily operations. So let me provide some practical guidance here in strengthening your compliance framework. We can expect that the FTC will look at board-level accountability. The FTC is watching whether senior leadership is engaged in oversight. Data governance and privacy are critical hot-button issues. With respect to advertising and marketing claims, precision and substantiation are just non-negotiable. AI and algorithmic transparency is a fast-emerging area of interest, and I encourage regular training, internal audits, and responsive compliance culture. So here's the key takeaway. Chairman Ferguson's FTC is not backing down. It's just recalibrating for a more strategic impact. Companies that view compliance as a competitive advantage will thrive. Those who don't may just face significant exposure. Compliance is not just a checkbox. It's your brand's best defense. So, ladies and gentlemen, stay tuned to further programs as we identify and address key issues and developments and provide strategies for success. As always, I wish you continued success and a meaningful day. Thank you.
Thank you for listening to Clearly Conspicuous. For more information on our Consumer Protection Defense and Compliance team, visit hklaw.com/CPDC or email anthony.diresta@hklaw.com with any questions about today's episode.